Okay, we are live. I am attorney Justin Sterling, a personal injury and business lawyer. This is Coffee with a Lawyer. We're streaming live on the digital airwaves of YouTube, Facebook, Instagram, X, formerly Twitter, and LinkedIn. This is your chance to ask the lawyer your legal questions for free. This is our pro bono legal services. This is why we do what we do, to help people deal with legal issues, improve their lives, and make a meaningful difference. There is no attorney-client relationship, no confidentiality, and this is important because what we say here could be discoverable in any litigation. So let's keep things general. This is only meant to provide general information and it's not specific legal advice. Let's keep questions general. If you have to speak about specific details, I encourage you to reach out for a confidential consultation with an attorney. And today we have a special guest. So if you'd like to share your name and just talk about your situation, I'm happy to give any information that could be helpful.
Am I the special guest?
Yes, go ahead.
Fantastic. I have a certain, it's a small claims kind of situation. I was placed, I'm a private chef, and I was placed to do a tasting with a family for 2 days, probably about a week and a half ago, August 29, August 30. And basically they canceled the night before. They had switched the schedule. They wanted me to do breakfast, so that started at 8. So for me, I have to get there. I mean, you know, it's a new place, it's a new house, it's a new thing. So I would think I would get there around 7:15 at the latest. So I'm looking at it, it's like 12 hours before. They canceled the following day at approximately 6:12 p.m. And I had, you know, already done a lot of prep and already purchased all the goods. And essentially when I asked to be paid or reimbursed, they declined. So I kind of went back and I said I would take off some of the food and I would take off the second day of work because I thought, you know, I'm trying to kind of move on and get this done. And they declined that. They basically offered me less than half of what their invoice is. So here we are, and I got some great advice from an attorney. I don't know if I'm supposed to discuss that. And I documented, with the help of ChatGPT, kind of a non-threatening letter with some facts in it. And I didn't know if it's appropriate, like ChatGPT put a lot of the legal terms in bold. My ex-wife is a lawyer. She thinks, you know, take away the bold. She also thought stating that this is not a threat is, she felt like it's not a legal thing and also it's disingenuous. To which I feel like the other lawyer said it's kind of imperative to make sure you say it's not a threat.
Right.
So I don't know if it's the right thing to include the verbiage, this is not a threat. I basically just, like, even if I lose a little bit, I kind of want to move on as opposed to going through all of the, I'm sure it's going to be a big pain in the butt to go do a small claims court for $2,000. $2,000, I mean, it's less than that. It's like $1,900, but it's, some of it's the principal, and also honestly that's a lot of money for, I think, anybody just to kind of walk away from. And I also feel like they are not doing the right thing. I can understand not paying me for the day that I was booked, but also I did an event the following, that Sunday. I could have been in LA prepping and gotten paid on that Saturday I booked with this family. So I feel like it's not the right thing. I feel like I've been very professional and respectful and communicative, and you know, even the placement agent, the guy from Beverly Hills, the estate manager is ghosting him. He's not picking up his calls. He's not responding to his emails. It's just really not nice. And that's kind of where we are. So I drafted this letter. I'm happy to share it in the chat if that's appropriate. That's where we are. I haven't communicated with this client since Sunday when they offered me $850, which I told them was not sufficient.
Understood. Well, thank you for sharing. What we can do is I just gave you some access to share your screen if you want to share the letter. And I'll avoid referring to you by name so we keep your confidentiality. As far as not saying that it's a threat and the advice from your ex-wife, that's good advice. I think there's ways that we can phrase things so it's not so direct. I do include some language to just protect myself so it's clear, because I'm always very concerned about that thin line between asserting your legal rights and committing extortion, because I don't want you to do anything that could backfire and perhaps you incur personal liability. I can put some language that I put in the chat, that I put in my general demands, but tone is important. And yeah, so I agree with the other attorney that an aggressive approach may not be very productive here. It's got to be carefully crafted with a nice, friendly, I wouldn't say friendly tone, but assertive, informed, knowledgeable, bringing it to their attention, documenting. Really, this is really a memorialization of evidence. This could be serve as evidence in any potential claim. And yes, it may not be the biggest amount in controversy, but you're in business. You should know how to handle these situations as a matter of course, because it could come up again. And the more efficient that you handle this situation, the better for you, because you'll be ready for the next one. You'll know what to do. You'll know how to avoid this situation. You can be more proactive. So I think it's important that you get this letter to be pretty much airtight for you. I put some language in there that I put in my demands, some general language. I usually put it at the end after I have a good assertive tone, and then it's just kind of like at the end as a disclaimer. Look, nothing in here should be interpreted as a threat of litigation or otherwise. Yeah, you want to appease them. Like, look, I'm not about to file a lawsuit. I just want to bring us to the table to resolve this, because you hurt me. You know, I put a lot of work into this, and you guys are hurting me. And I want you to know that you're hurting me. And if you continue to hurt and you don't come to the table to resolve this dispute that I'm bringing to your attention, I'll have no choice but to file a lawsuit, whether that be small claims or in unlimited jurisdictions, because I lost out on opportunities. Now, you talked about how you suffered like a foregone opportunity, that you could have done some other jobs. Now, you're going to have to support that. You can't just claim that I could have done all this. Well, that's true, but do you have something that amounts to something real? Like, was there something on the table?
I have the invoice that I sent them for the day of work on September 1st of the event.
Okay, but that's regarding you and the other party. But what about the possible other opportunities? Like you said,
so the other opportunity was in Los Angeles on the following day, September 1st. So they had two events that day. I could have prepped for that event, two events I don't know if that's enough data showing that I worked on September 1st. Basically, I just have the invoice that I sent to the client. So different client, different thing, which also I haven't been paid for. I got to follow up with them. But potentially I for sure could have made the trip to LA and worked to prepare for those two events.
Well, that's something in your communications with the party that didn't show up for you, that you're upset that they didn't pay you for. I think that's something you should keep in your pocket. You can bring it to their attention. Look, I have support that because I relied on your representations, I missed out on other opportunities that could have led to lucrative deals for me because I relied on you. I sacrificed. I was there for you. Now it's time for you guys to be there for me. I substantially performed, and now it's time for you guys to perform your end of the deal. But yeah, I do agree with the other attorney. Tone must be appropriate here. It's delicate. It's a thin line when you're asserting your rights because you want to be careful that you're not going to commit extortion. I don't think your language would go to that extent. So maybe you don't need to include this is not a threat, this type of disclaimer language. But there's just some people when they get in a dispute and someone owes them money, they just immediately go total berserk and say, I'm going to sue you. I'm going to go to the FBI is a common phrase. I'm going to report you to the police, and pay me an amount that's not reasonably related to what is in fact owed. Like pay me $1 million or I'm going to report you to the police.
Right.
When you just owe me $1,000 or so. That's extortion. It has to be
Right.
reasonably related.
Should I copy and paste this letter into the chat?
If you'd like, yeah, you can. I don't think it will be publicized, but we can review it in the chat. I don't know if you have access to sharing your screen, but I'll review it. We can take a look at it.
What's easier for you? Share the screen?
Yeah, if you can.
How do I do that?
Are you on a desktop?
Yeah.
I'm not the most tech savvy person, but on Zoom, there should be a feature on the bottom menu bar that says share.
Yeah. Got it.
And I made you the co-host so you could share.
Got it.
Actually, okay. Actually, I think maybe we should just copy and paste because I want to avoid showing any confidential information. So we can just stop sharing your screen. I want to be careful not to.
Okay.
So yeah.
Stop that.
There you go.
And I'm going to do this. And it's over the limit. Okay, so let's hold on here.
If it's over the limit, if you feel comfortable sharing,
I'll break it up.
yeah, I got to give that disclaimer again that this isn't confidential. This is subject to.
Yeah, it's fine.
You could be discovered in any litigation.
Okay, I'm sharing it. It's okay. I'm living on the edge.
Okay.
Can you see that?
Yes. Okay. Let's see. Well, I like how you started. I hope you're doing well. The first sentence is very important. It sets the tone. The private chef service is scheduled for August 29th and 30th. Okay. I purchased all necessary ingredients. Yep. So I could be prepared for breakfast. You're pretty exact with your time. That's okay. I think this shows that, you're documenting things. The second day of service was being canceled. At that point, the goods had already been purchased and prep work completed in reliance on our agreement. I like that language, in reliance on our agreement. I like how you are asserting that we have an agreement. That's your position. We had a meeting of the minds. If you want to put that in there, you want to throw some legal lingo, you can even put that in that second paragraph. We had a meeting of the minds.
Okay.
Yeah, that's a legal term of art when dealing with contracts. That's what a contract really is. It's a meeting of the minds.
Do I put that in quote?
Yeah.
Meeting of the minds?
You can just say it just like we had a meeting of the minds, period. It was an understanding that I would perform these services and I would be compensated. You can say that as well if you want, but let's continue reading. Let's see what else is said. I like how you just said it. We had a meeting of the minds. We have another guest entering, just so you know.
Cool.
So let me just acknowledge Sherry. Can you hear us? I think her audio is connected. Sherry, you're on mute. We are addressing a legal issue right now, but if you can hear us, just stay tuned and then I'll get to you.
Hi, Sherry. Good morning.
Mic check. Okay, well, let's continue. So, in addition, because I was booked with your family for both days, I declined other opportunity. I wouldn't say I declined. I said I foregone.
Forego.
Yeah, I forwent. I don't know how you say that word, but it's a foregone opportunity. Because when you say you declined, it's like you took assertive action and you rejected it, so you weren't going to take it anyways. So I suffered a foregone I suffered foregone opportunities. Because it's what did you suffer? You suffered a loss. I suffered foregone other opportunity. I mean, I like that phrase. I know it might not be grammatically correct, but
Suffered foregoing opportunity. Okay.
no, I don't like that. It's foregone. And I know sometimes when we write grammar, check doesn't really pick up legalese. It's sometimes attorneys don't really speak grammatically correct, but because it's a different language, really. I suffered for, you could put it in quotes. Maybe that would, I suffered foregone opportunities. I suffered how many foregone opportunities? Well, technically, in layperson's terms, it would be I missed out on other opportunities.
I missed out.
Yeah, because I relied on your representations. Say, in addition, because I was booked with your family for both days and I relied on your representations, I missed out on other opportunities.
Relied on
Your representations in good faith. I missed out on other business opportunities. Specifically, I worked at an event in Los Angeles, but I was invited to work with the same company on August 20th to assist in preparations for those events. I turned that opportunity down out of commitment to the Hall family. Fair? It may be revealing a little bit too much, but that's fine. I think it's fair. It gives you some factual background. The total cost for both days, including rebirth, comes to, while I understand, then you can also say the total cost for including reimbursable expenses comes to that. While I understand that scheduling needs can change under the principles of breach of, this is where it may get. I wouldn't say, and I know we already said we already included some legalese in there with meeting the minds, but I wouldn't say under the principles. I would say under. You can even say at this point, I consulted with legal counsel. I understand that scheduling needs can change. However, I consulted. I understand that scheduling needs can change, period. However, I consulted with legal counsel. And I have been informed that under I would say that under the principles that informed under the principles of breach of contract and detrimental reliance, I am entitled reimbursements and the services rendered in good faith. And then I would even put comma along with the harms and losses that I suffered. Along with the harms and losses that I suffered in reliance on your representations. Because then this is when you can add on those loss of opportunities. I would say, along with the harms and losses I suffered. That's fine. Okay, this letter serves as a request for that full payment will be made. Always give them a time. All right, you don't want to leave it open-ended because you want to know, if they don't, oh, there you go. You have 14 calendar days. I didn't see the next sentence. That's good. That's fair. Because even if they don't respond and no response is in fact a response, then you know what to do.
Mm-hmm.
I kindly ask that payment be arranged within 14 days of this letter. How do you want them to pay you? I'd like to make it as clear and easy for them as possible.
Through Zelle or Venmo, is that fine?
Yeah, I would tell them the terms. Like, how do you want them to pay you? Well, how was it originally agreed? Through our original agreement through Zelle or Venmo, as we discussed.
Venmo or check.
And then let them know where to mail that check. Check, they could probably still fool you by saying, "Yeah, we mailed the check,"
Right.
So I don't know, something more immediate. Or contact me to make other arrangements. Do they have your Zelle or Venmo?
Yes.
All right. Would say through Zelle or Venmo, as we discussed, or please contact me immediately to make other arrangements. Okay, so if payment is not received within the time, say timely. If payment is not received timely, comma, I will have to treat this as a breach and may pursue recovery through the court and pursue recovery of the full amount allowed by law.
Mm-hmm.
Okay.
This meeting is being recorded.
Sherry, you're on. We have an echo, Sherry. I'm gonna have to mute you.
It's muted. Sorry.
Yeah, sorry. We have a what do you call that? An echo, a bounce. Okay, so if payment is, I will have to of the full amount allowed by law through the courts. Please understand, this is not intended as only a clear statement of my rights. That's fair. I like that language.
Now, she said take that out, not intended as a threat, because it sounds disingenuous.
Okay, well, let's maybe not make it so bold. Let's see what I put in my, let's make it a little bit, let's massage it a little bit.
Okay.
Let's make a new paragraph where it says, please understand this is not. And, legal professionals, minds of legal professionals can differ. There are, many ways you can achieve the same result. So please understand this is not, okay, please,
we could just take that out because we have your verbiage at the bottom.
okay. I mean, and I know who you spoke to before knew you on a different level in a relationship. So perspectives are everything. How people, and who you're dealing with too. And when you write this letter, how they're going to interpret this. So
now, should this just be copied and pasted into an email or created into a PDF and my email says, please see attached letter? Or is this fine, just email it like this?
You know, I kind of like also how you kind of have this paragraph that you pasted after your signature, because it's kind of just like a disclaimer. You can even put like, an asterisk, like just kind of disclaimer language, like don't interpret this as a threat. This is just a notice. All right. So I kind of like that, how you have it. You can say warm regards, because, like then you have like your letter, nice and good tone, and then like afterwards you're just putting this in there because you have to, because you got to let them know that this is not a threat. I'm just asserting my rights here. So I like how you have that. Ideally, send everything with some form of tracking, so you have proof: certified mail with tracking, registered mail, FedEx sometimes. And I know
So this can't be emailed. I need to mail it.
well, look, you can, but it's always good to have proof, because then, 14 days go by and you're still chasing this people and they're like, oh, wait, I never opened my email, so they kind of have that excuse. I actually, when I send emails, I have some form of tracking on my emails. And if they don't have their tracking blocking, I can tell when they open it. And that confirmation can serve sometimes as some form of proof. I kind of live in that world of evidence. Now, how they operate. You could probably just copy and paste this and shoot it by text, by email. When I send notices like this, I do like to have some form of tracking and confirmation. I'll send it by fax, email, text, and certified mail with tracking. So, but that's just me. I represent other people, and I need to secure that proof that they in fact received it. I think you could be well off with just shooting it by email and then follow up with a phone call and be like, "Hey, did you get my email?" So it's a case by case basis, but there's no rule saying you have to mail this. I just say, you know, to send it by certified mail so you have some form of evidentiary proof. So if you do have to file a complaint, you say, look, I gave them this notice, I gave them this opportunity, and they still disregarded my rights. Otherwise, if you don't have any form of proof, no form of tracking, it never happened. It doesn't exist. Ultimately, the most secure method, when I really have to make sure people got documents or received my communication, I'll have a process server serve them and submit an affidavit that they actually gave them the documents that is described. They come as a witness and say, I gave them this document, and this document was this and that. Licensed or registered licensed process server.
Do you feel I should remove the bold from all of this, the text, and just keep it, or does it make sense to have the bold?
It's a preference. I like the fact that the amount jumps out. I like, the certain terms that you have bolded. I think it has an effect. Subconsciously, you glance at a document, you see the amount, you see breach of contract, detrimental reliance, request for adequate insurance, 14 calendars. I would underline 14 calendar days, bold and underline that one. I think it's fine. I think it has an effect. I do things, I do that type of formatting in a lot of my documents because it has a subconscious effect. People don't always have the time to really sit down and really read things, but when you bold and underline, it jumps out quickly. I think this is a good letter.
Have promissory estoppel on there and cure of their breach.
Well,
Do you think
you have detrimental reliance.
Okay.
That covers it.
Okay.
Cure of their breach. Right now you're requesting them to give you assurances that they're going to perform. That will cure any worries that you have. You just want to receive money. And I think you have the proper legal terms. It's nice, it's concise. You have a factual background here. It shows that you suffered even additional losses with loss of opportunities. I think this is a fair letter. I think it will have an effect. Now you know who you're dealing with. Some people are just, they don't respect other people's rights or positions, and they may just, ignore it. But remember, a no response is in fact a response. Do you have any questions? I don't know if Sherry, if you're following along, we're talking about basically
Hi, Sherry. Thank you for listening.
Thank you. I'm not used to using Zoom, so believe it or not.
Your sound is coming
you're
in.
doing great.
Yeah, your sound is great now. But
I
that
had two windows open, that's why.
it happens.
Mr. Sterling, you
Yes.
represented me on a Whole Foods slip and fall and won years ago, like 15 years ago. I'm Worley the Clown.
Yes,
Wow.
I recall.
Yeah.
How are
So
you?
when I saw, hey, listen, I don't want to interrupt on your letter. Are you done, or do you want to do some more? Do you have any other questions?
Justin, are we done?
I think it sounds good. I think we've reviewed it thoroughly. I'd like to give Sherry the opportunity.
Yeah, of course.
Sherry, do you have any questions?
Yeah, I don't know if you can help me. Mine's a different case. I was displaced January 7th of 32 years of my rent-controlled apartment in the Palisades fire. I'm still displaced 8 months later. My building is standing, and she was just supposed to remediate. They haven't repopulated because they're having problems with the gas line. But I had a lawyer, Sonia Mulhall, up till 3 years ago, but she retired at 95. Wow. And they can get a lot of money from my apartment. I'm probably the only rent-controlled condo in LA, and I'm the only one who keeps paying rent since the fire. And so what's happening is now I have, I need a tenant attorney. I don't know if it's something that you do, but July 24th, she illegally locked me out and said, your belongings aren't there. And she asked me earlier in March to take out all my belongings to remediate, which I didn't need to do, but she said, oh, we're going to upgrade it. And she hasn't done the habitability. And what she's doing is just collecting rent and illegally locking me out. I went to the police, and the police said it's a fine line, that maybe she doesn't have money for insurance. I could probably go back and get a report done. I've talked to the LAHD, and it's under investigation. She changed my mailbox keys and went through my mail. I actually have voicemail where she's actually went through it and said some things, I'll keep the important stuff for it. And I told her I'd not to go with Jesus. We text, I said, that's illegal. And so I got a key back. But so the question I have for you is, this is a big case. I was exposed to asbestos. They lied and said they had a clearance certificate when they didn't. It's really big. And a lot of big tenant firms said they take it only if I don't go back on contingency. And I want to go back to my rent-controlled apartment of 32 years in the Palisades. Right. And it's just about money. So the first question that I can't get an answer from, I talked to legal aid for 2.5 hours, and I can't get a straight answer. Lawyers just want to write letters. And no offense on politics, but she has Trump syndrome, and she just doesn't believe in the law. So writing a letter, unless I'm going to have some action, is going to do nothing at this point. And I wanted to ask you, should I, on the illegal lockout, it still hasn't repopulated yet. And this is the last thing, and this will make sense to you. I'm all over the place. I apologize. I'm tired. The HO, one of the owners told me that the apartment complex is under Fannie Mae blacklisted, which means that if they get renters out, the price, it will be off the blacklist and the value will go up. And so they're actively trying to get rid of renters. And her tone has changed where she's using the HOA attorney, obviously. And then they just said that if we do a gas workaround, we can get the hot water on, but we can't get cooking. And the building is too old to put electricity. And they said that it might take a year or two. So renters aren't allowed in. So all this is really illegal. So the thing about it is, it's such a fine line. Like if I was not the fire, and it's not, and it's retaliatory, because the reason that she locked me out was I called Los Angeles Building and Safety and took a video, because she said it was asbestos and cleared, and it wasn't. And so she got in trouble. You see what I'm saying? So that's why and now she's making up stuff that I'm interrupting workers who I've never even seen a worker there, so it's basically, trying to get me out. And unfortunately, the LAHD has a program where you pay rent into the REIT program or the tenant habitability program, but I don't qualify because I'm a condo. And I'm grandfathered from a 1994 law that changed where you can't have a rent control condo, but I moved in 1992. This is where I'm at. And I have talked to 40 lawyers, and I thought of what a great job you did with me at Whole Foods, because I really did hurt myself. So I appreciate you.
Mm-hmm.
It's funny, I live right by it and I go in there all the time.
Mm-hmm.
And you were nothing but great with me. So I thought, when I got your email, I thought, I'm almost at wit's end. I have rent insurance. It's very low and it ends in December. And everyone just says this is a gray area because of the fire. There's only 1,000 units standing. All my stuff got ruined by soot. I had some stuff I could have kept in there. I did put a safe in there, and I asked her to keep it in there. That was nothing in it, and she did take it out. So this is, I talked to some police in Marina Del Rey, and they're like, yeah, she's trying to get you out because she could rent for $4,000 more a month. I don't blame her, but my lease is valid. So is this something that you do?
I do not do landlord and tenant issues, but your case spans many different issues here. And with these landlords, especially taking advantage of people in a vulnerable position, it's like price gouging. It's very unfair. It seems like there's a lot of violations and injustice going on. What I'm going to do, and I know you spoke to a lot of attorneys, I'm going to give you a source, and I put it in the chat. I don't know if you reached out to the LA County Bar Lawyer Referral Service.
No, I haven't.
I am on their executive committee for the LRS, Lawyer Referral Service. It's called Smart Law.
I'm going to take a picture. No, I haven't done this. Okay.
Yes.
Okay, I just got up. I can see. Okay, awesome. I'm going to do that.
Yeah, make sure you take that information, because once we sign off, it disappears.
No, I took a picture on my phone.
That's great. So I would reach out to them. They will get you in touch with the right type of attorney. And I don't know if it's necessarily strictly landlord tenant. It could be a class action. I'm seeing, a class of members here that are being treated wrongly by the landlord. So there's a lot of issues here. And Perry, if we can take your screen down right now.
Yeah.
Yeah.
Got it.
Yeah, there we go. I just wanted to see.
Justin, you do personal injury. I know that I was exposed to asbestos. And I'm the one that has, the colloidal cysts where I have the brain tumor. That's why I stopped doing Worley. It's not cancerous, but I could die. I know this is being recorded. This is so weird. Most people know this.
Well, I should let you know, yes, we are being recorded. No confidentiality here.
Okay.
No attorney-client privilege, which is very important because this could potentially be discoverable in any future litigation. So let's keep it general.
I have nothing to hide for litigation. Just question on the asbestos. Is there anything, because you have a lot of integrity and you've always delivered. And I'm just not getting, I don't know if they're overwhelmed in the courts or the fires or whatever. Is there any way, I know the referrals, I've gone through so many, you know what I mean? Is there any way that you can help me?
What I can do is, because this is a matter of first impression, I need to really get a feel for the case more. So I'm always here every Monday. Let me just learn a little bit more before I can decide if I'm the right attorney.
Can I send you a timeline, not the evidence?
The timeline, yes. You said you had a nice timeline, and that's always.
Yeah, I did on ChatGPT. I have a really good one, and I have full evidence. I mean, that's why big firms want to take me, but they only want to take me if I don't go back. And that's not my priority. My priority is I want to go back home.
I understand that. I also understand with Asbestos. Sorry, guys. I'm just trying to adjust my lights here. The battery.
And I'm
went.
63, I'm a protected tenant.
Okay. I will say with asbestos and mold cases, they're difficult cases.
Okay.
Because you need to have microbiology testing. It's causation is going to be an issue. Was this condition caused, in fact, by the asbestos in the property? It's very difficult to prove that causation element. So we need to
Well,
get.
they did do abatement, and I do have text saying they found asbestos and it was from the fire. And she said that she had a clearance certificate, and the HOA, which has deep pockets, said they had one and a report on file when they didn't. And I went in to film and I said, no, it's not remediated. I had a thin mask on, but nothing much. And then I go back and I film for 2 seconds. This is why they locked me out, that they had sheeting with asbestos, and no notice was ever given to me. And so, and in May, she said they found asbestos, and they said, we're going to do abatement this week. So I thought it was done when I went in.
Well, it's important to do that chronology and save all the documentation.
Yeah, I do.
What you can do is send me your timeline. I would encourage you to reach out to Smart Law. And
I'm going to do that today.
Yeah. And then let's just take it one step at a time. Because this,
Justin, what's your, is it the email that you sent this link to?
yes, Justin
Okay.
at thesterlingfirm.com.
No, you were awesome. I would be honored if you could have anything to do with this. You were nothing but just stellar. Out of all the lawyers I've ever used, so thank you.
I appreciate the kind words. I do remember your situation. And what I can do at the very least is give you some form of comfort to know that I'm here every Monday. So
Okay.
even if you find an appropriate attorney through the LA County Bar Association, and I encourage anyone who's searching for an attorney to reach out to
Okay.
it's called Smart Law. It's a very, very reputable referral service. Like I said, I serve on an advisory executive committee, and I'm also a volunteer attorney with them. I'm not a volunteer, but a panel attorney where they refer me cases. It's a very great organization. They cover the whole state of not just LA County, but also the whole state of California. And very good attorneys that they refer cases to when people are in need and they don't know what kind of attorney or who to contact. So this is always a great resource. And when I can't necessarily represent people, I always tell them to contact the LA County
cool.
Bar.
I'm going to do that right when we get off. And I appreciate you offering your services on Monday if I get stuck on a question.
Yes.
Like, I don't know if I should go attempt to do another, go to the police again and do a report, or just wait until they say it's habitable.
Well,
They could say,
from my perspective, I always like more reports, more documentation, more memorialization. The more times,
there's no downside, because this policeman was, no offense, he wasn't very cool. He was like, oh, maybe she doesn't have any money. And I know if I go back, somebody, because she goes, well, how much do you pay for rent? If I go back, I know that somebody will fill out a report. So you're saying, like, there's not too much evidence, which you taught me that. I have videos, I have over evidence. If anything, everybody's been impressed with how much evidence I have. I don't answer with the landlord, so I get a voicemail. You know what I mean? So I will, and then the other thing is, do you know if it's legal? It's a cluster box. According to ChatGPT, she's not supposed to have a mailbox key because it's a cluster box. And I can't get anybody to give me the advice if that's legal or not, that she has a key.
I think a landlord-tenant attorney would know the answer to that.
I know, but I can't. They don't unless they represent you. Nobody will give you the answer.
Well, another good thing about the LA County Bar, their attorney referral is obligated to give you a free consultation. So a free 20-minute consultation with any referral from the LA County Bar.
So I can write down my questions. Okay.
Yeah, I would come prepared That's always a good thing to do before you speak to an attorney, so you can use your time efficiently. Come prepared with your questions to ask, and so you can be productive during your time that you consult with them.
Justin, this is great. I appreciate it. This has been nothing but stellar. I really appreciate it.
And then I also just want to reassure you that I'm here every Monday. And like I said, if I'm not the attorney who takes your case on, it's always good to have the ability to get another opinion, to just tap into a legal resource along your journey. A legal dispute is really, it takes on a life of its own. So it's good to tap in here, tap into the source, find out what's priority so you can address it for the week ahead. That's why we're here Monday, first thing in the morning at 9 a.m. So you can get some clarity. Maybe I can't give you the answers that you need for your case because it may be outside my practice area. But at least you can get some form of clarity by speaking with another legal professional, another attorney, and then be able to understand what issues you need to address and take them on take them
No,
head
you
on
just
and
helped
for the
me. I'm
week.
gonna go do the report because they were back and forth. And then other question I have is the LAHD. I had one investigator when she went through my stuff and did a legal entry in March. That was great. Wrote her a letter. They can't enforce it, but it's tenant harassment, so it shows a timeline.
Mm.
So this new one I've had has had my stuff since July 21st before the lockout. And every time she calls, she just, obviously she has too much of a caseload and she goes, I can't do this. I'll review it later. And it's been over 2 months. Should I ask for a different investigator? Is that any downside?
I think it would be helpful. If you're not getting any progress with this investigator, let's reach out to another one. You may have to
Okay.
go to a different department, another
No,
police.
no, it's only one department. It's LAHD. And there are only a
Housing
few. I called the old investigator who was really great. And I didn't say anything bad about her. I just said she hasn't reviewed it. And he said, no, I can't take it. We just have a big caseload. And she
Understood.
just is obviously, it's like, when you get someone and they're just not that good. But I don't want to put myself in a bad light with LAHD. I need them to be favorable.
I agree.
So do you think I should ask for someone else or just I've called her, she hasn't called back? I mean, you know what I mean?
I would say probably go in there in person.
Oh, that's a
Yes.
great idea.
And try to see them eye to eye. Get a
Yeah,
feel.
and if they see me, I'm not. Oh,
Yes.
that's a great idea.
If they can put a face to the name,
Yeah,
feel the energy, feel that you're sincere, that you're really, you're in trouble here, you need help from the authorities. I think that would be helpful. Now,
No, that is perfect. I'm going to write that. Okay, hold on. I'm just writing that. Already you've helped me tremendously with the referral. I'm going to do the lockout. I did file with the U.S. Postal, and I'm going to follow up on that. I think I'm going to call. Oh, and you know what? Councilman Tracy Park's office is near me in Venice. I should go. I think going in person is really great. That's a great idea. Getting anywhere.
I think so, because a lot of the political representatives, I think, are open to taking on these matters because it's a matter of public interest. I mean, the fires, there's a lot of people who've been displaced and are still, I mean, Jesus, has it been a year? Has it?
No, 8 months. And I
8
was
months.
at ground zero. The fire was out my window.
Yeah. And
I mean, I'm really lucky I'm here. The only thing I came with my car and my rabbit. And
Wow.
I'm very, very lucky that I'm here. And the other thing is I'm working with just between you and me, but I haven't gotten anything from FEMA. I've appealed it
was I
5
gonna
million
say?
times.
That was exactly was no insurance claim payouts. Where it's been 8
The only
months.
thing was
People
Red
are
Cross.
homeless
It's been
still.
a lot of fraud, yeah.
Yeah, a lot of fraud. So I would say your representatives may be a good source because they may want to take on this matter and kind of make some publicity out of it.
And
So
the last question I have, can you have like 2 lawyers? Like, can you have one for habitability and for the harassment? Because sometimes that's all tenant a company does, and then have one in case she does some dumb eviction or illegal something that I have to go? Can you have two representation?
I would say technically you can, but it depends on your attorney-client agreement. So you want to
Okay.
be clear with that and understand what they're representing you for. And perhaps if you want to have another attorney for this other area, you got to be very clear about that, because there could be some conflicts and it has to be disclosed.
Okay, I'll be straightforward. Okay, that's cool.
And there may have to be some consent given between those attorneys, so you guys are all on the same page. I will say what you've done, which is probably the most important thing that I encourage everyone to do, and in your situation as well, Perry, is
Mhm.
creating that timeline.
Do
That's
it on
most important.
ChatGPT. It's great. It does it, and then you know what's cool? If you ask it and say, "I want the pictures to go with the numbers," I have a file on Google Drive. It took me 3 months to figure this out. I'm old.
Mhm.
And
Mhm.
you tell ChatGPT your case. It's so worth it. And then it will put it in chronological order, and it makes it very clear. The only problem is that sometimes it changes your wordage. So you have to be very
What?
detailed. Say, do not change a word. Then you have to
Okay.
read it over because it makes up shit sometimes. And you're like, don't say that. And then on my file, I have like this date, and I have a dated video and pictures. Like Justin taught me this a long time ago. You can't have too much evidence, right?
This
Right.
is true. You bring up some good points, but let me just tell you the uh, importance of creating that timeline is really about getting your story straight. You know, so much, we know what happened in our mind, and then time goes by and then other things happen. And it's just the story gets distorted. So we have to memorialize things so we get our story straight. That's why I tell all my clients, let's get our story straight. This is our story and let's stick to it. Let's get it down and memorialize it. Well, I will also give a forewarning though about ChatGPT, because even in the settings, when you click the setting to make things private, we really don't know if that's
Yeah,
being put out to the public.
yeah.
So we want to be careful with what we put into ChatGPT, and also what you put into ChatGPT could be discoverable, just like what we're talking about here. And I know you're pretty comfortable and forthright, but we just have to be careful about that, because if
Well,
we
I'm doing nothing wrong. So whatever anybody finds out, and just out of curiosity, because this is being recorded, what is this used for?
uh just general information,
I mean, do
anyone.
you put it on YouTube?
We're streaming on the different platforms. Yeah, we are on YouTube.
Okay, so if my landlord hears this, it doesn't matter because what I'm doing everything up front. I'm just trying, there's no strategy to beat her. I just want to go back and say that this is not cool.
I
I
don't
have the law.
Yeah.
Yeah.
I don't think you revealed anything that is, damaging. It's only
Yeah.
supportive to your case. Honestly, if they did discover this, it would just be another piece of memorialization and fact that supports your position. Um, so, but that's my biggest advice, is getting that timeline, that chronology, and getting your story together. And it will be helpful. So when you approach the authorities, or if you speak to other legal professionals, you have it concise, and the key facts. That's what we look for, is the key facts. The key facts are those in which the case turns on.
Thank you. And I appreciate all this. Can I use your name on the referral?
For the LA County Bar?
Yeah.
Absolutely, yes.
Okay, because I'm going to call as soon as we get off the phone. I have to do one thing, and then I appreciate it because I'm doing this all on my own, navigating this, and just the little stuff that you told me about going in person and then filing. You can't have too much evidence, and for the referral, it was huge.
Well,
So really,
let's take it one step at a time. And what I can tell you for sure is that more will be revealed after each step. Everyone wants to know, like, what's going to happen at the end. Well, we really don't know. Let's just take it one step at a time, and more will be revealed. More will be continued, to be continued. And I'm here every
And tell your
Monday.
mom and dad that they did a good job with you.
Yes, I appreciate that. Well, thank you,
But they're
Sherry.
so on. It's so
Yeah.
good.
It's good to see you, and it's good to hear from you, and good to connect. I'm happy you followed up with me. I do remember our previous situation, and Perry as well. Yeah, it's good to see you as well. And guys, I'm here every Monday, 9 a.m.
Thank you.
We can adjourn now. I like to keep these generally brief, maybe like 20 to 30 minutes, so we can start our week and start taking action. This is really just a space for us to tap into and handle our important just tap into and just get focused for the week ahead, because legal issues are very important. They have a lot of significance. So I'm here first thing Monday morning, tap into, bring your questions, bring the issues, and so you guys can attack them head on for the week ahead. Sound fair?
Appreciate you very much.
Thank you
All right.
very much for your
Yeah.
time, Justin.
Yeah,
Good
but-
luck, Sherry.
Yeah.
You
But-
too, you got this.
Yeah. Thank
I'll
you
see
guys.
next week. Thank you.
Yes. Take
All
care.
right.
Take action.
Bye.
Bye for now.
All right, bye.